Ladies and gentlemen, good afternoon. Welcome to this afternoon's session, where I'm joined by 4 lawyers. Wow, 4 lawyers in the same room. This could have been expensive, couldn't it? At an hourly rate, this is about £4,000 sitting here until about 3 p.m. So we should all be very honoured because they're not charging, it's all free. So on that basis, I'm hoping that you will be very vocal in terms of asking questions and maybe not grilling them as such, this isn't a court, but certainly asking questions, any burning questions you've got that obviously relate to property. We've got some specialists here, and I'll ask the panel to introduce themselves in a second. I'm Russell Quirk, by the way, so I'm a kind of property guy. I do a bit of media. I run a PR firm which is predominantly focused on property companies. I've been a house builder. I've been an estate agent for many, many years, so kind of property's my thing. But what these guys are all about is the legal, technical aspect of property. So let's start off at the end with your introduction, if I may.
I should have come in earlier.
No, not at all.
Okay, well, my name is Julie Condliffe. I am a specialist auction solicitor. I've written 3 best-selling books on auctions and 1 on general property investment. I'm also a landlord. I've bought over 42 of my own properties at auction, and I also sell at auction. So I walk the walk and I talk the talk.
Wow. You've done that before, haven't you, that line there? That's good.
Yes, I
have. Good. David.
My name's David Smith. I'm a partner with J&W Solicitors. I'm probably better known to you as the legal counsel for the NRLA. I generally specialise in novel areas of property litigation, but I'm particularly known for my work on the Housing Act 2004. And my book on HMOs is out in 2 weeks' time. My second book on HMOs is out in 2 weeks' time.
There's the second shameless promotion of...
Yeah, shameless self-promotion.
Why not? We're not paying them, so we've got to give them some licence, I guess, to self-publicise. Your turn.
Hi, good afternoon. My name is Sehar Hussain. I'm a solicitor with Hennah, Haywood Law. We're a firm based in South Wales, and I specialise in conveyancing, so sales, purchases, remortgages, you name it, and we can deal with your files.
Brilliant. Thank you. Robert?
Yes, good afternoon. My name is Robert Bolwell. I'm with a firm called Dutton, Gregory, based down in Wessex. My strapline is, we make people homeless, which in simple terms means if you have a difficult tenant, hopefully we can sort it out. And I have to admit, yes, I have been a landlord, but I've never written a book, and that's me.
Very wise.
Yeah, I think you should. You know, you're in good company here. So,
I am.
You should maybe take some tips from these guys. So next time you can announce your book is on sale at Amazon or whatever. Well, look, on that note, let me ask a question. And as I say, I'd love questions from you as an audience over the next 45 minutes or so. But I'll start us off, I think, on the basis really that Robert has just sort of touched on in terms of making people homeless. Now, I know obviously he says that with a wry smile, but there has been, and potentially will be even more so in the future, real issues around possession. So perhaps we can talk about that in a bit of detail. The question therefore, I guess, would be, if you are a landlord with a difficult tenant, what can you now do legitimately to help remove that tenant? And what do you think is coming down the tracks, given obviously everything that's been talked about over the last year or two about Section 21? What do you think the politics hold for the future in that regard? Robert?
How long we got? Okay, at the moment, if you've got a tenant who's being difficult, if they've actually broken the terms of their tenancy agreement, they're in arrears of their rent, they've upset the neighbours, whatever it may be, you can serve either what's called a Section 8 notice, a default notice, and that gives you the right to start court proceedings, usually in a fortnight's time. Or if you're coming to the end, or you've got to the end of your fixed term tenancy, you can serve this thing called a Section 21 notice, which is usually 2 months. And again, that would give you the right to go to court at the end of the 2-month period. Now, the problem with both notices, they each have their unique characteristics and challenges. If you start on a default basis, when you get to court, unless you're going on what lawyers would call ground 8, where you had 2 months rent arrears when you serve the notice, and you've still got 2 months rent arrears in front of the judge, then you only have a discretionary right to get your property back. The judge might say, no, I'll give the tenant a second chance. So you might be £1,500 out of pocket and no guarantee you'll get an order. The great thing about this Section 21, the 2-month notice, when your tenancy is coming to an end, is if you've got all your ducks in a row, all the paperwork is right, the judge doesn't have much of a choice. He has got to give you that order. But I think David will probably come in here. The problem we have with Section 21s is, they are going. We have a white paper that was published a couple of months back which says the white paper is going to support a bill which will get rid of Section 21. So in the future, There will be a few exceptions, but in the future, the general rule will be you can't get a tenant out unless you want the property back to sell it, you want the property back for a member of your family to go in there, or some other grounds based on the tenant doing something wrong. And that's going to change the whole way in which landlords have to approach the situation of dealing with difficult tenants. And it's all very well sitting here saying, well, we don't know what the law is going to be in 5 years' time, but every major political party is on the record as saying, no, we want to get rid of this no-fault eviction business. We want to have a situation where there is more security for tenants, not less. So I think, Dave, unless you tell me otherwise, I think it's going to happen. We just don't know when.
David, anything to add?
Yeah, I mean, I think the one thing I would say is I wouldn't panic about it. Yeah, I've seen people already saying I'm going to evict all my tenants because of Section 21 and sell all my houses. But the reality is that even under the Boris Johnson government, the fairer renting bill, assuming it appears, is not going to come into force for at least another 2 years. So it's not exactly a hair on fire situation. And the reality is that all the ministers involved in that white paper are no longer in government. I mean, literally all of them have gone.
So do you think it still happens?
Well, I think it's quite notable that of the various points the fairer renting white paper put forward, there are two currently being consulted on. One is or being discussed seriously. One is the property portal, which is landlord registration, but we don't like to call it that because that would be landlord registration, and the government said they wouldn't do that, but the property portal, which is landlord registration by another name, and the decent home standard. So I suspect that the reality is that the current Prime Minister is not noted for her keenness on regulation, is likely to water things
She could always change
down.
her mind, couldn't she?
I can't possibly
Just saying.
comment on mind changing in the government. I mean,
A U-turn, maybe. I mean, it has been known.
It has been known to happen. My guess is that they're actually pulling back on the Section 21 stuff. But then you've got to bear in mind that they've got to have an election
in less than 2 years.
In less than 2 years, and as things currently stand, they ain't going to win. And the Labour Party's position is very different.
Yeah, and it does seem that, I mean, not just now, but in the last 2 or 3 years, that whether it's the Conservative government or Labour and the Liberal Democrats in opposition, they've been very, very keen to turn the tables against landlords, not just in terms of Section 21, but in terms of tax relief being eroded and so on, in favour of the tenant. And I guess just to make a political point, see if you agree with me, Sehar, it's because they see tenants as an open goal in terms of getting them on side as voters, do you think? I know we're not here to talk about politics, but law and politics are not that far apart, are they?
No, not at all. I think definitely the aim is that there's more tenants than there is landlords, so they would aim for that. But I would say that even the legislature is to protect the tenants. However, if as the landlord you're seeking the right instructions, obtaining the right advice to how to draft your tenancy agreements, to have the right tenancy agreements in place, to have the right deposit schemes in place, then if a breach does occur from the tenant side, then you're protected because you've taken the right steps. I think a lot of problems occur for landlords when they haven't taken the right steps when they're letting their properties out, which then causes further issues for them.
And do you mean by that they haven't consulted a lawyer, they've done it themselves?
Yeah.
So what would your recommendation be then to a landlord in terms of putting those steps in place properly?
I mean, from personal experiences, I've seen a lot of landlords that might just download a template of a tenancy agreement from the internet and get the tenants to sign. That could have been uploaded by anyone. That could be outdated. So it's important to either seek estate agents or law firms to be like, okay, am I pursuing the right tenancy agreement with the tenants I've got in place, and have I got the right deposit schemes in place, because these are the pinpoints that a tenant could kind of get you on if they wish to do so. And they have, they can even seek compensation if the right measures are not taken. So I would say, yes, the legislation is there to protect, but it's also there to protect you as the landlords if you've taken the right steps. So that would be my main, advice to landlords.
Thank you. And Julie, I guess add to this by all means in terms of your view on how a kind of fractured landlord-tenant relationship perhaps can be concluded. But let me put you on the spot. Do you think Section 21, that a relinquishing of Section 21 goes too far?
Absolutely, I think it does, because all the current regulations at the moment are said to be protecting tenants, But I think they go too far. They protect tenants, doubtless, but I think they disadvantage us as landlords.
Do you think MPs
So
have
I
a
think-
misunderstanding of, I mean, there's no fault eviction. I mean, the perception by the media is that 3 months into a 12 months AST, the landlord can just ask the tenant to leave. And of course, that's not correct. So, so-called no fault evictions are a bit of a misnomer, I think.
Well, they are. I couldn't agree with you more, Russell. Because as landlords, even with the no-fault ones, we still have to serve an eviction notice. But not just that, you've got to wait for it to expire. But not just that, you then have to join the court system, the queue. But not just that, you've got huge delays. But not just that, you attend a court hearing. You're not guaranteed of having possession, even if your paperwork is in order. If a tenant hypothetically just basically says, there's disrepair, judges normally just say, okay, we'll adjourn it, allow the defendant to file a defense, even after the time has lapsed. So I'm very, very passionate about these matters, A, because I'm a landlord, and B, because I'm in court loads of times trying to defend fellow landlords, against a government.
And
would
what would your advice be to government then? What should they do rather than just relinquishing Section 21? What's the answer to trying to appease tenant groups but also to protect landlords in terms of them not exiting the sector and then us ending up with the unintended consequence of a shortage of stock?
They should stop using the legislature as a beating stick.
As a political football.
Or absolutely, for the landlords. They should just stop it. They should expedite the process for us.
Yeah.
Because at the moment, if we serve a Section 21, we've got the 2 months, and then, it falls into the court system. Sometimes 4 months, you don't even have a court hearing. We are hemorrhaging money because we are still paying the mortgage, do you see? So I just think it's unfair.
And David, you're in your capacity as legal counsel for the NRLA,
I'm going to disagree. I think you're shooting at the wrong target.
which should be.
Well, because you're mixing.
Am I going to have to be judged
You're
here
mixing
between you
no,
two?
you're
It's fine. I can
you're
fight
mixing-
with David all day long. So that's
You're mixing
okay.
totally different things. The reality is the English market is the least regulated tenant market in the whole of Europe. And the complaint you're making is not actually about Section 21 at all. It's about the speed of the court process. And I
Well,
completely agree.
well, yes, but I didn't say the complaint is about Section 21. I said the complaint is about the eviction process, and the eviction process does include Section 21.
the question was, should it
also
be
includes
repealed?
Section 8.
But
So
they're
it-
different
and-
processes.
Sorry, yeah,
They're
I'll let you carry on.
So-
but yeah, this is not like litigation between you and I.
No, it's
So
not.
the
We're
court-
not in a court.
the court
Okay,
But it's starting to feel a bit like that.
The court process, in my view, is the courts are totally broken, and I think the court process is the problem.
So we agree on that, because that is the point.
And did you think that's a COVID thing in terms of backlog and
No, it was
the changing legislation, the emergency legislation put in place to
No,
protect tenants?
The courts
They've always been
were a
broken.
travesty before COVID. COVID made
Absolutely.
it worse. The
We've
whole
got a
thing
new
was just
Justice Secretary now, Brandon Lewis. Surely he's going to fix it all.
Well, you can only fix something if you're prepared to spend money on it. The reality is that the government is appallingly short of judges. It can't get judges to people to apply for judicial appointments. The most recent judicial appointment competition for junior judges didn't even fill the 100 slots it was trying to fill, and they've re-tendered it because not enough people are prepared to come forward and be judges. And judges aren't badly paid. But the government's cut their salaries, it's increased their working hours, it's made their pensions worse, it's made their working lives more unpleasant. Most court buildings have leaks in them, and non-working lifts and all the rest of it, so why would you want to work in that environment? People who are judges, generally speaking, have a choice because they're all pretty decent lawyers. So why choose to work in a crappy environment? And then you've got a shortage of bailiffs. The government currently pays bailiffs under £15,000 a year. Would you want to be a county court bailiff for that kind of money? And it's short around 200 bailiffs by its own count. So why do you think there's a problem?
But how will government pander to the politics of protecting tenants if they retain Section 21 and actually speed up the court process? That means more tenants will be evicted and quicker.
Yeah, well, then there's a different question. The reason that
So what's the solution?
So
I
the
guess,
reason
is
that
my question.
government talks a lot about protecting tenants is it's looking for
It's votes.
easy wins on votes.
It's politics.
Because the reality is that until relatively recently, tenants didn't vote.
So David, you have just basically agreed with everything I've said.
I didn't disagree with you. I just said you were shooting at the wrong target by having go at Section 21.
You started
This
off
is gonna
by
get
saying-
good. Stick
you
around,
started
guys.
off by you started off by saying I disagree.
Well, I
So when
disagree.
you say you
I
disagree,
disagree with the conception that getting rid of Section 21 is a disaster. I don't think it is.
So you agree with the Section 21 process?
No, I said I don't think there's a major problem with getting rid of it.
So what's the solution? What's the solution?
Provided you uprate Section 8 so it works more effectively and make the court system actually work. The reality is people are living in homes. These are homes. The fact of the matter is, unfortunately, and it annoys me to see it, there are a percentage of landlords who abuse the process. And unless you improve the court system, you won't deal with that. And and tax, I think, is a separate issue. The reason that people keep having to go at landlords about tax is because it's an easy way of getting money, of course.
Julie, just come back and then we'll go to the other panellists just so that they don't feel completely left out.
Sure, I hear you, but I don't agree. I don't agree purely on the premise that, hypothetically, I'm a landlord, I've got a tenant in situ, they've paid rent, they haven't done any wrong at all, but I need to take back my property to sell it. And yes. I don't have Section 21, so it's a no-fault ground.
Is this a battle between left and right?
Well, as I said, the Section 8 notice should have more grounds that would cover this.
Sell it with a tenant in it.
Well, easy says no, because a lot of conveyancers don't recommend that you should do that. Robert?
Can I look at Scotland? Scotland got rid of their equivalent of a Section 21 in 2017. And the market up there for the rental sector has not collapsed. There is some anecdotal evidence of 1 or 2 landlords have sold up, but there is still a vibrant rental market in Scotland despite not having a Section 21 equivalent. But they have a housing court. They have specialist judges, specialist courts that deal with stuff that in England goes in a general run of the mill. So if you've got a possession case today, your judge yesterday was dealing with a divorce, tomorrow he's dealing with a road traffic accident.
But Robert, to David's point, we're never going to get to that position.
No.
There aren't enough judges to fill the spots that we would need to be
The
housing
minister
judges.
responsible for the white paper that said let's get rid of Section 21 was Michael Gove. Okay. Anybody like to guess who the Justice Minister was in 2010? That started cutting up to 250 courts in the last 12 years. Anybody like to guess who that was? It was Michael Gove. So, I apologise if I sound a cynic when it comes to politicians, but that's the problem we have. One day you've got Michael Gove cutting left, right and centre, and we're surprised why we have a problem with the court system at the moment. Next day, he says in the white paper, we need more resources. Well, where's he been for the last intervening 12 years? At the moment, David's right, the court system is broken. Not enough judges, not enough bailiffs. Anybody here got property in East London? If you issue tomorrow in what's called the Stratford Housing Centre, used to be called the Bow County Court to you and me, you won't get a hearing for 4 months. If you've got a property in Romford and you're in the Romford County Court tomorrow, you won't get a hearing probably for 5 months. If I'm in leafy Winchester, I'm in court in 6 weeks. Now, if we go back to pre-pandemic days, there was actually a rule that the courts had to list every possession case, whether it was tenant default or a Section 21, they had to list it at least 8 weeks after you issue. Somewhere between 4 and 8 weeks, you were guaranteed a hearing. That rule went out the window even before we had the first lockdown.
Have things got any better
No.
now that COVID is somewhat behind us?
No,
So the courts are still clogged up.
No,
Worse
The
than they
courts
were.
are still clogged up. You probably...
Is your experience?
Yes, I would agree that I feel like...
So, can I just say, Stratford Housing Court, I served the Section 21 in December. I submitted the documentation to Stratford Housing Court in March. They wrote to me in July to say they've got the documentation but hadn't yet been in touch with the tenant.
I know.
And they still have not sent the papers to the tenant, and it's October.
I think you need a good lawyer.
Yeah, you need to make a
good
complaint on
lawyer.
that. I would write to them and make a complaint about that.
Yeah, you write to
That's
the
typical, though.
the court manager, then you write to the complaints guy, and then after that you say, I'm now writing to the Minister of Justice, and you might get some action. But I have to say, and I don't mind going on the record, the service from certain courts in this country is absolutely diabolical. It is very much a postcode lottery. And of course, you don't have much choice. If you're dealing with a residential tenant, a residential property, you've got to start in the county court and you've got to start in the court local to where that property is. So if you're in Winchester, great. If you're in East London or Romford, well, I apologise now. I was saying to David earlier, most of my time 20 years ago was dealing with the law, dealing with tenants going to court. Now most of my time is explaining to poor old landlords like you why they are waiting so long when the rent arrears are going up day after day after day. If we're going to get rid of Section 21s, and, I've got no real beef about that, we need to follow the Scottish example. Put some more resources in and have a housing court. So when you issue your proceedings, because your rent arrears are at the 3-month mark, you'll have a hearing within 3 weeks. Not 3 months or, sorry, in your case, even longer.
So just for balance, I guess that's my job really. Is there anybody in the room as a landlord that has had a somewhat successful time of it with courts and dealing with tenant issues, particularly over arrears and repossessions? Anybody? So that's a big fat no then. Sorry?
Through Section 21, but not through Section 8.
Right. But in terms of the pipeline of process and progress, I mean, so has anybody been mildly surprised at how fast the process has undertaken? No, nobody. Right, okay.
Says it all, really.
Yeah, it does.
Sorry.
You're talking about the court delays. If you're going to litigate against or take somebody to court, can you decide which court it gets heard in? So if you've got Leafy Winchester,
No.
can you say
The court are required to hear it in the court that deals with where your property is. So the only way you can decide it is by buying your property in the first place in a quiet court area, but you can't predict those up front. I mean, what I would say to people is you should bear in mind, and certainly I find this a lot, that a lot of landlords are quite obsessed with getting a money judgment against tenants. You should bear in mind your prospects of collecting your money are very poor.
Yeah.
And I always say to landlords, if there's rent arrears, it is always worth making an offer to wipe out the arrears if the tenant goes. I say that to everybody.
Even if it's a zero offer, potentially.
I always try to wipe out rent arrears and refund the deposit if the tenant will just go. It will save you money in the long run as against the current delays.
Especially if you're in East London or Romford.
Especially if you're in a challenging court. I mean, it's frustrating. I appreciate it really sticks in the craw to give away money.
Yeah, but it's a commercial.
But at least you're getting your property back, and you can rent it to somebody who's going to actually pay you.
Yeah.
Can I ask on that point, when are you most likely to be able to get their money back? Is it when they are employed and you can put a charge on earnings? Or
The best ways to get money back are, I mean, this is why I will say that the two best references you will ever have as a landlord are somebody's bank statement, so you know what their bank details are, and somebody's employment slip, their pay slips, you know who their employer is. But if you want to enforce a judgment, you really kind of need to know where the person's gone, so you need to try and find out where they are physically in the world afterwards. And then the best solution is either attachment of earnings, so attach of earnings at source, but it does depend what they get paid.
So you could just be getting 50 quid a month for a long period of time.
I've seen people getting under a £5 a month for the rest of their natural lives.
And there's no interest on that arrears, presumably, is there?
No interest is also is added, but it's quite a low rate.
Decides at what rate
It's decided by a centralised government body called CAPS.
Right.
And then the other option is to go after their bank account, and you can freeze their bank account and take what's out of it. So that's why knowing bank details. But then the other option is to go after people who have got physical assets. But the problem at the moment is that people don't tend to have physical assets anymore, and you'll know yourselves. What assets do you have? Your houses, but people don't have gold watches. Most people don't, in fact, own a car. It's on some lease deal.
But if they own consumer goods, those consumer goods in terms of bailiff value are much less.
Are worth nothing. People always say, "Oh, they've got a big screen TV," but you can buy a big screen TV for 400 quid, and after it's been through a bailiff auction and been sold, it's worth 50.
You've got to follow up.
I have a HMO. The tenant's fine, but the guest is antisocial. Is there any way a landlord can bar the guest from entering the building? Do I have to get an injunction? Is there any way? Or is there any clauses I can put in the agreement?
Have you spoken to the local authority? Because I think the local authority have some power, don't they? Again, I'll bow to the better knowledge of my esteemed panel here.
Yeah, I mean, effectively, you all know what an ASBO type order is. If these people are causing problems, go to the local authority. I'm a great one in believing that why should you pay for a lawyer if there's a legal team down in the local borough council that should be sorting it out? The difficulty is always, it's like involving the police. Usually they don't really want to know.
Yeah, the police came round and they said to the tenants, contact the landlord. And I'm thinking, well, what can I do?
Well, I know.
But the police will only deal with it in the moment. They're not. Don't have the power to do anything in terms of future enforcement or banning, do they?
Absolutely right. If there's a breach of the tenancy agreement, then yes, in theory, you can get an injunction to stop that particular breach. But if you've got a difficult occupier, a difficult tenant, and he's not listening to you, is he going to make much difference? He's going to listen to a bit of paper from the county court. The reality is you come back to, do we serve a Section 8 to get it out, get the property back, or can you, in the situation, serve a Section 21? You've always got to look at what the potential expenditure is against the benefit. The other thing to bear in mind is with tenant disputes like that where it involves a neighbour. I've seen many, many cases where the neighbours are really vocal. You serve your Section 8, you go off to court, and then you ask the neighbour to come along, give evidence to the judge 6 months down the road in Stratford, and they don't turn up.
Yeah.
And of course, if you don't have the evidence on the day, by definition, you lose the case. So you've got to think very long and very hard.
So what is best advice for this gentleman here in the situation that he's got?
I would speak to specialists. It's very difficult to evict tenants for antisocial behaviour.
It's fine, it's the guest. You know,
But the tenant's liable for the guest's behaviour, and you can potentially evict the tenant for that. You need to, I would threaten the tenant with potential eviction if they don't resolve the problem. But this was one of the ironies of the Fairer Renting White Paper. The government said they were going to fix antisocial behaviour by tenants. But how can you fix it? The reality is that the courts have to hear an antisocial behaviour case. They can't just say, "Oh, you've been accused of antisocial behaviour, so we'll just evict you," because that wouldn't be very reasonable. And the government magically said, "Oh, it was going to make it better," but judges are very reluctant to evict for antisocial behaviour, and the government can't legislate its way around that.
Well, of course, if such things as Section 21 are repealed, then the landlord has even less means with which to work.
And this is this is kind of the bonus and the problem. People often use Section 21 where lots of other grounds of possession are available, but the trouble is, in some senses, that plays into the government's hands. Because they say, well, you don't need Section 21 because there are grounds for eviction for rent arrears and for antisocial behaviour. But you've got to prove it. So the difficulty, though, is that Section 21 wasn't intended for the use that it is frequently put to. It was intended to allow people to sell and things like that. But actually, it's used just as much for evicting for rent arrears and antisocial behaviour, which wasn't its purpose. But that's partly because the existing mechanisms don't work well, because the court system doesn't work well.
Julie, anything to add?
No, not at all. I agree with Robert and I agree with David in that you just have to carry out a time and cost-benefit analysis.
Yeah, make a
You can
commercial
go
decision.
Absolutely. You can go down the injunction route. That's going to cost you time and money.
That's
Or
what you
yes,
do,
and
whatever
this is it. So
Yeah.
it's a commercial
Great.
decision.
So any other questions? Yes.
Yes, so thank you for this panel. I learned a lot because I'm half tenant, half the owner of the property, so no, I can't be...
Sorry, you're half tenant and half owner?
Yes, I was in house...
What, as in shared ownership?
Shared
Right,
ownership.
okay.
So and I have a complicated situation and to ask you a few questions. So when I was buying the flat, it's a very expensive development in London, so I was shown a show house. And certain expectations were set, and when I moved in, so they were not fulfilled, and with the time the house is going, the quality of the house is going down. Also, I found out that there was a mixed tenant, so half house and party, half shared ownership.
And that wasn't also explained to you
it
at the
wasn't
point of
really
sale?
explained
Right.
to me
Yeah.
by the lawyers as well, neither by housing association nor by the lawyers, so I just found out when I moved in, basically.
And could you give us a couple of quick examples as to what was represented to you that did not then come true?
Basically, there was a foyer, a nice foyer which was furnished with clock, mirrors, and everything.
Yeah.
Nice lift and nice upholstery all over the house. When I moved in, there was nothing in the foyer, and I was told it will be there in a year. It didn't materialize.
So you feel it's misrepresentation?
I think it's mis-selling because it's very difficult to sell the house now, and the price of the property is going down because of the mismanagement of the house. Also, during the pandemic, we had homeless people because the door was broken and
Wow.
they wouldn't fix the door, so we had a lot of issues, police involved as well.
So is
The
your
court
question, what is your redress?
Case, because now I've heard that the court case can take a very long time.
Do you want to take this?
So I would like to file and we kind of formed a shared ownership association as well, because there's loopholes within the same system. And see if there's a case for mis-selling in the first place, and how we can sort out the mismanagement, because we tried to talk to poverty, and unfortunately during the last year and a half it doesn't lead to anywhere.
So let me ask Sehar to answer that, but I guess the question, the obvious question is, have you made any representations to the developer in the first instance? So have you asked them to respond to your concerns before you start considering legal action?
Yes, we did, but what's happening, everything that was expensive is basically, if we have repairs, if there was an expensive lift, now it's a cheap lift. If there was expensive carpet, now it's a cheap carpet, so everything is going down.
So, Sehar, what are your thoughts?
It's difficult to sell because people come to the foyer and they see it's mismanaged.
Yeah.
And we were shown the houses, I was shown the flat in the building next door, which is still amazing, and they're flat properties right now.
Okay.
Price.
So the panel will answer. I suppose I should do my bit in terms of, isn't there a caveat here in terms of your responses here, because it's a misrepresentation thing, that this is not kind of advice that you can be sued for if it goes horribly wrong. Yes, let's just make...
Everything you're about to hear is without prejudice, as lawyers would say.
That's
okay?
it, good.
Right.
Sehar.
How many years ago did you purchase the property?
7 years ago.
Right, so essentially, and it was a new build property?
Yes.
Yeah, so with a new build property, you usually get building cover which can range up to 10 years. So you're still within that time range. I mean, a lot of the time when you're buying a property, the lawyer that's dealing with your purchase has to review all the legal documentation and produce a document called report on title, which they present to you with all the enclosures. So I would definitely have a look at that to see exactly what you were notified of at the time of your purchase. And this is customarily done.
Well, and in the
Report on
contract,
title.
presumably, and the contract itself.
Yeah.
The contract you see,
The contract is more binding, but the report on title is more explaining, you know, your title deeds, your rights, what's coming with the property, and it has enclosures, and that's usually provided to you prior to exchanging, which is what makes your purchase legally binding. Reverting back to the point of the building cover, that's up till 10 years, and you can request, even though it should have been provided to you at the time of your purchase, that covers what's included in that. So I would obtain those documents and see exactly if any of the issues you've highlighted come within those aspects detailed within that cover note. And you know, sometimes you might represent a complaint and you might be given a no at the first instance. But I always say, you know, every establishment has a higher up authority. So if you can't get what you want from the first hurdle, you know, move to the second hurdle, because every establishment has that backup in case the first hurdle disagrees.
Thanks, Sehar. And do you still have material from when you bought the property? So do you have a brochure? Do you have email representations that said, this is how we're going to address the lobby and so on? Do you have that evidence as such? Okay, that's interesting. David?
So your mis-selling claim is a misrepresentation claim. It's probably dead because the Limitation Act is 6 years on this. So you're at 7. Your claim against your conveyancing solicitor is covered by a different limitation period, so might still be available to you. If, I presume you pay a service charge?
yes.
So if the management company is not managing the property properly, you should explore whether or not you can take a claim in the tribunal in respect of your service charges, which are potentially excessive for the quality of service you're being provided.
Good. Julie, anything to add?
No.
What would you do? What would you do if you were in this lady's position where she clearly passionately feels that she's been done over by this horrible developer? Don't name them, please.
I think my good friends have covered the pertinent points, and there's no need to repeat what they have said. You find yourself in an unenviable set of circumstances. So where there's a blame, you know, there's a claim somewhere. So you want to just go through that hierarchy, as they said. The solicitors, did they do what they were supposed to do? Did they give you the information that you were supposed to get? But not just that. Did you also, I'm sure you did, but did you also have a clear understanding of all the literature that they gave us? Because sometimes they give us a show home and they say that it's, you know, just a representation.
It's not representative.
Absolutely, it would look like this. So there's quite a lot that we need to basically.
Robert, what's your view?
Yeah, I'll pick up David's point. You've got 3 claims. One against the developer may be dead because it's normally 6 years to actually bring a claim. There would also probably be a clause in your sale contract which says that only things which have been specifically communicated to you in writing by the developer will be part of that overall contract. So for various reasons, your claim against the developer might be dead. So far as your conveyancing solicitor is concerned, every conveyancer will ask what are called preliminary and additional inquiries of the seller. And there'll be sheets of questions where you ask things like, who are the other properties going to? How is it going to be maintained? Now, if your solicitor didn't ask the right questions, or he did, but he didn't put the answers on that report in title we just mentioned, yes, you could have a claim against your solicitor. But again, but you need to check this. And then the third claim, as David said, is against the management company. Under the terms of your lease, your agreement, your tenancy, your 50-50 ownership or whatever, the management company has got to maintain that property to certain standards. What are the standards set out in that documentation? If they're not doing it as they should, yeah, you've got a separate claim there because you're paying service charges. So you've got 3 claims, one of which almost certainly dead, one possibility, and then the claim against the managing agents. That's probably where I'd start and have a look.
What about the association?
Well, is there an association?
Housing association, but they're managing.
Yeah, well, yeah.
So they own the shared, the bit that you don't own, effectively, the housing association.
It's owned by the housing association.
Yeah.
And I'm paying mortgage on 25%. and the
Housing
rest
associations.
Are they responsible?
Yeah.
to manage the
Yeah.
property.
Housing associations are famously bad at private sector management and famously bad at dealing with claims against them for service charges. It's always worth exploring service charge complaints with a housing association because about 80% of the time they completely cock it up.
And will cave in.
And end up giving up in the tribunal or make a complete hash of it.
Yeah, and just before I come to your question, what about costs? So what does someone that stands up in the audience that's a member of the public, what does that member of the public do when it comes to facing the prospect of a legal action for something that they feel very passionately about? I mean, the costs of 1, 2 or 3 legal claims, I mean, that's not inconsequential. How do we navigate through that as ordinary members of the public?
That is a problem. So I didn't mention this, but the service charge claim is made in the tribunal about reasonableness, and the tribunal is normally a no-cost jurisdiction. So your prospect of obtaining legal costs are very low, but you will find there are solicitors who specialise in service charge claims who are much cheaper than the kind of fees I charge.
Are you able to recommend one at the end between you?
I don't recommend.
No.
Write something down and pretend you wasn't.
But there are a fair few, and there are plenty of names out there. You can find them on the internet, and they have Trustpilot reviews and so on.
There's something called the Leasehold Advisory Service.
Yeah,
If
I
you
would start with
simply Google Leasehold Advisory Service, they're brilliant. It's a government-sponsored agency that help people like you. 2 other things, though. Number 1, if the problem is with the management company and the stair carpet, if you take them to court and you win, who's going to benefit from your stair carpet? Everybody in the development. So if you are thinking about this, don't be afraid to go and knock on doors and say, look, would you all like to, chip in a bit to help us get this sorted?
Or maybe even an informal petition,
Yeah.
perhaps.
So,
We did. It was,
So a group-
We wrote 20 pages and sent it to this housing association. I'm not named.
the other
Nothing back?
there is another more budget option.
Nothing changes. Like we have a meeting every month.
Yeah. There's
David has a
There's
cost
one
magic
one
bullet.
other more budget option. Your management company is probably required to be a member of an ombudsman scheme, and you could complain to the relevant ombudsman scheme in respect to their management, which is basically,
Some ombudsman is in charge of it, right?
in theory, yeah. You need to check, but your management company is probably required to join an ombudsman, and they will potentially make you a financial award without or tell them to do stuff. And obviously much lower cost, very much structured not to involve stinky lawyers.
So some great advice there. So we need to move it.
And one thing, also check your buildings insurance policy and your car insurance. Very often these policies, they come with a legal expense policy added on that you don't even know you've got.
And home contents, yes.
Yeah, and home contents. Have you got a clause in any of those policies that say, yeah, we'll help you with legal fees if you dispute? That can be
So we
valuable
wish
as
you the
well.
very best of luck. Now you've had all that wonderful and expensive advice. wish you luck. No problem. This lady here, you had a question.
Mine is a developer contractual one at JCT.
Okay.
That's not me.
A little bit, but we'll go on.
Okay. So it goes back to trying to claim some money for someone. So I'm doing residential development. I have had a builder, a contractor come on site who's cocked up putting the wrong RSJ in, tried to charge me for that, but then when he realised, tried to charge me for his mistake, when he realised that he wasn't going to get away with that, he found it easier to walk off site, taking a big chunk of our money with him, which I think he hadn't done. We are faced with a situation because the contract, JCT style contract, is in his limited company name. His famous words as he walked off site, "So you like I'll fold my company."
Yeah,
as builders
happens
do.
all the time.
Yeah. So it sounds as though we've got not much recourse because he can either strip his limited company of assets so that if we took legal action, he could just say there's no money in the company to pay. He could do as
Have you checked? Have you looked at Company's House, looked at his
There's a
balance
time
sheet?
lag. It's not. It's not. It's
No,
not.
No,
it's
but
a
you get a good
compound.
idea. You get a good idea.
My neighbour is
There's
in
not a lot
exactly
in
the same
He does
place.
a lot in cash. There's not a lot in his company. He could easily manipulate the situation.
So he could wind it up.
Huh?
He could wind it up without a
Wind it up
second
could be
thought.
not much- yeah, I'm just wondering what other.
Okay, you have two options. I mean, one, I'd question whether the JCT contract's binding on you because it's generally not intended for use with consumers, and quite a lot of the clauses in it won't be binding on you if you're acting as in your own property as a consumer.
Sorry, this is development.
So this is
This
a
was-
retail.
this
This is
was-
a development.
this was
Residential development.
So it's not for
investment.
So
you
you-
to live in. It's for
No.
for
So it was a
firms.
business. It was a business deal.
Yeah.
Okay, so the JCT or short form will be binding on you. It probably has an arbitration clause. JCT short form generally has an arbitration clause,
Yeah.
which is worth looking at. As regards a limited company, pretty difficult. You would have to sit and explore whether any part of the contract could be said to be informed with him as an individual, as opposed to with a limited company. But if you've signed terms with a limited company, you're in a pretty difficult position. I mean, I would start though by paying a few £100 and getting a Dun and Bradstreet check against the company, and see what their
it's
assets
worth.
are.
If it's worth hundreds of thousands of pounds, he can't and won't just liquidate it because it's too
Yeah,
perilous.
Builders say they're always going to. And do bear in mind that one option would be to simply serve the company with a statutory demand. If you can say that with some conviction they owe you money without bothering to go to court, you could seek to start insolvency proceedings with the company and get the administrators to sort it out, because they will then look for money and they will start chasing. And they have powers to start chasing up people who strip their companies of money to prevent this kind of nonsense.
Isn't there statutory demand where there's no dispute about the outstanding amount of money? That's what.
Well,
I've
they
understood.
can then dispute it, but he's got to choose to do that, doesn't he? And if he does dispute it, then the court will decide.
Did and look, I'm not the lawyer here, but did you pay him anything in cash?
Yeah.
You did.
Yeah.
So is there not an argument that you paid that to him as an individual rather than the limited company, therefore he is personally liable?
Did you
potentially?
receive the cash
Email receipt
from his company or from him?
from him, which is his company's email, from him individually. But
From his company's email address.
You could scare him a little.
You could try threatening him. But yeah, I mean, I would. It's quite a complex question. You need
Yes.
to go and speak to somebody. But you're going to find it difficult to bore behind the limited company structure. I mean, it exists for good reasons, but it's also open to abuse.
Have you given him a really
I mean,
horrible Trustpilot review?
I mean,
seriously.
That's pending.
Yeah.
Yeah.
I would do it because you always remove it. So do it, get his attention, and see what he comes back with. Because if it's true, it has to be true and accurate, and it's scathing enough, he might give in because he wants you to take the review down.
What about Checkatrade? Because on some of
Yeah.
them they insure.
Yeah, but you've got to have used. You can't like Checkatrade if you didn't
Checkatrade
go through
cover probably
Checkatrade.
doesn't extend to companies.
Sorry,
Checkatrade's cover primarily extends to consumers,
not.
and you're not. I mean, the point,
Trustpilot, Google, those two.
the point I should make here, and I'm sorry to make this point to you after the fact, but way too many landlords are way too trusting of limited companies. I see this in the rent-to-rent context daily, in the context of agents, letting agents who have appeared this week and disappeared next week, and in your context as well.
I wouldn't say I was too trusting. It's just the way that it's.
It is very difficult with builders, I'd say.
Yeah, I mean, if you're having a contract, I mean, there's not many options.
You don't
apart
expect them
from
to walk
the-
away, do you?
Sorry.
You don't expect them to walk away, do you?
No, or cock up quite that badly.
Yeah.
Well, I don't agree. I mean, there are ways to check out limited companies.
No, and I did check him out. I did loads of due diligence, but at the end of the day, if the limited company hasn't got the money, well, he can engineer, so he doesn't have them. But who else would you sign a contract with? Him as an individual? I don't think there's many contractors.
No,
that
he
do
wouldn't
that.
do that. But there's also a lot of bluff and bluster by those limited companies, I think is the point. That it's easy for him
Yeah.
to say, I'll just wind it up and you've got no redress at all. I think you need to test that further.
Yeah, yeah.
JCT.
Personal guarantee.
Yeah.
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 Don't pay cash.
Right, indeed. Sir, question?
Is it possible to stop a company being wound up if you have a dispute ongoing? Can you contact Company's House and prevent the winding up of that company?
You have to make an application to the High Court.
You have to be a creditor, I guess, do you?
You have to have a reason. You have to make an application to the High Court. The High Court will order Companies House to prevent winding up. But you have to have an ongoing dispute.
And you have to do that before they've wound up the company, presumably.
No, you
Maybe
can
afterwards.
do it
You do it
afterwards.
retrospectively.
You can have it unwound, but it's much harder.
Right.
So if you're in a dispute with a company, what solicitors do is we have services that monitor companies we're in disputes with and alert us. But obviously, Companies House will, if you keep an eye on Companies House and follow its timeline, it will tell you when the company's got winding up orders.
Alerts
you
on
put,
Companies House.
and
to
Companies
get
House
alerted
has
if there's
alerting
any
now.
When it gives notice.
Yeah.
Yeah.
But that is grounds to prevent, is it? If you have an ongoing dispute, if you actually...
Yeah, you'd have to make an application to the High Court, but it's a common practice and it's a common issue. It comes up in prosecutions as well. Limited companies seek to wind up when they're being prosecuted by local authorities.
Moving forward though, in terms of what's the best way to protect, we've got QS, we've got, you're saying overly trusting limited companies. What's the other option?
Well, sometimes you just accept the risk. I accept that.
Insurance.
But, due diligence, insurance.
Did you
And-
did you ask if he had any insurance before you instructed him?
Professional indemnity, for instance.
Well, there is insurance, contract work, and there is a professional indemnity add-on, but I think it's a professional indemnity add-on for him, to say we were to sue him. There's two types of professional indemnity.
It's to pay out a claim if he loses.
Yeah.
Sorry?
It's to pay out a claim if he loses.
Yeah, but then that just goes into his limited company bank account, and we wouldn't...
Not necessarily. You want to. I would speak to the insurers about this, and see if there's any avenue you can go down
Sorry.
if he's got insurance.
If he's got insurance, then you can prevent the money going into his bank account. If you make a claim against him, you win it, and the insurer is about to pay out, you can obtain a third-party debt order against the insurer to make sure they pay you directly.
Yes. Proper side.
That's probably your best avenue. Speak to the insurers if you've still got that policy.
But would the insurer speak to me if I'm not the policy holder?
They will do if you're making a claim.
Yeah.
Okay.
You want a claim form.
I think we need
That's
to
the
instruct
first
a
thing.
lawyer, which is what this is all coming back to. We need to move on. I mean,
Okay,
great
yeah, sure,
question,
thank
brilliant
you.
answers. My friend James Forrester, question.
Yes, so question about conveyancing. What should be getting done now to speed conveyancing process? It's an all-time high. We can't wait for legislation, obviously, to take control to enforce the speed limit.
Just been up Sehar, that's right up your street, I think. So how do we solve the problem of conveyancing?
Well, which part of the problem are you trying to
The
solve?
fact that it takes months and months and months,
4 to 6 months at the moment to get completion.
and it's got longer and longer, despite the fact that technology now exists, such things as emails and telephones and all sorts.
I mean, customarily, I would advise that property purchase or sale, mostly purchase, can conclude within 3 months, even quicker. It depends on a lot of aspects. It depends on whether you're purchasing a freehold. Freehold is quite straightforward. Depending that your searches come back quickly, you can get the transaction through within a month, provided that your seller agrees to that timescale. Where it gets a bit more complicated for conveyancing firms is if you have a lender in place that is not willing to accept a no search indemnity, and they're saying no matter what happens, we need those searches to come back. That's a third-party delaying factor that firms can't control. Or even your seller is saying, "Oh, I'm not ready. I need
think
2 or 3 more months." I think it all depends on what the
I think
transaction
the
includes.
theory of conveyancing is exactly what you've just set out.
Yeah.
We all know, though, as buyers, sellers, and indeed estate agents, that the practicalities do
Yeah.
not quite match that theoretical nicety. So, 3 months becomes 6 months, let alone leaseholds. And I suppose, look, we don't want to start pointing fingers here in terms of blame game. Is it the estate agent constantly badgering the conveyancer every day? Is it buyers that don't send back their forms, or indeed sellers not sending back their property information questionnaires quick enough? What is the solution here in terms of the practicalities as they are and the reality as it is? How on earth do we speed up the conveyancing process? Julie, what do we do? How do we fix this?
Yeah, great question, by the way. I believe in auctions, so the response I'm going to give is really going to be auction biased. In auctions, you can put your property up on the market for sale, get it sold within 4 weeks, 28 days later, you've completed. So clearly, we're doing something right there.
And Julie, is that, sorry to interrupt, that's because all the information is provided up front?
Well, absolutely, that's the point.
So bring back
Russell.
home information packs.
Yes, well, I don't know about home information packs. I don't know about home information packs, but yes, the theory behind that is a really, really good idea. So it's actually getting all the information prior, whatever relevant information it is, if it's searches, if it's whatever it is that's needed. Let's get that information up front to stop delaying the whole process. And if auctioneers can exchange contracts, surely, agents can do all that work up front, and by the time the file goes to the solicitors, they can just, check the documentation.
The only way that can be done is
do
if the
exchange.
estate agent takes that responsibility, because of course the conveyancer is not engaged until later, so it can't be the conveyancer that does that. So the estate agent, presumably, we're saying has to take responsibility for this?
Yeah,
Yes,
I agree.
Russell, sorry, Robert.
No, I agree to a certain degree. The problem we've got is if you're putting your property on the market today, as you said, you instruct the estate agent on Monday, and then your lawyer probably 3 weeks later when you get a buyer. If you instructed your lawyer at the same time you instruct the estate agent, all those preliminary inquiries, all those additional inquiries, all those things that take time would be done before you even have a buyer in sight. So yeah, home information packs is a partial answer. The other thing, like I said over here, insurance. If you buy a property in North America, you don't have local searches.
Yeah, title insurance, yeah.
You have insurance. Now, we can do that in this country. We did a transaction a few months ago in 36 hours. Because nobody wanted searches, we simply bought an insurance product.
But will lenders accept that premise?
Most will now, but it's the cost. So if you want a transaction to go through quickly, yes, you can do it in 36 hours. Everybody else in the chain is going to be with you, but it's going to be a cost. That's why in North America it does cost somewhat more, not because the lawyers charge more in North America, because you're paying the insurance companies. So that is one way to speed it up, but we're not there yet.
And David, what's the magic bullet? You must have the answer.
I'm not
Come on, tell us.
I'm not a conveyancer. I sue conveyancers primarily for negligence.
And so you should.
But I sort of agree with Robert. I mean, the reality is that the US system works much better than ours because
and some states don't even have lawyers in the
well,
conveyancing
no,
process.
I mean, yeah,
it's all title insurance. Like Florida, for instance.
In states where estate agents operate as the whole piece, then I think it's a much more efficient system. The government's hinted at it a couple of times, and has talked about, for example, trying to require estate agents to have lease information packs at the point of showing. But the difficulty at the moment is that there are too many parties involved, and so it's not so much that one party is slow, it's that everybody is slow, and your delays mount onto each other, and we need to break that away. And there are changes that are coming along. For example, more and more local authorities are putting their search function into the land registry, so you're actually getting one single search point, which is quicker, but we really lag horribly behind what is possible.
We have one of the worst conveyancing processes in the world. I think it's second only to Papua New Guinea in its inefficiency. And I'm not even kidding, it really is. James, can I throw it back at you? Because obviously you own an estate agency business, a sizable estate agency business in the West Midlands. What's the answer? Let estate agents do it, you'll probably say.
Sellers have to start paying up front slightly to make sure that everything's put together as a pack. I think it convinces the seller a lot more. The buyer knows that when the key trick in the property world is your finance ready. It's the first question you'll get in the estate agent today. If you're in a chain, they don't really want to know, even though you can still go and view it. People want people cash ready or mortgage ready to go. So
but having information up front, and maybe I think the responsibility is partly, but probably mainly on the estate agent.
Quid up front, for example, it's on all the information there ready, and that speeds the process up by about 3 months. That's a good thing. So they haven't a few weeks.
But what are the chances of the estate agency industry adopting that responsibility without legislation forcing them to do so?
They won't happen.
But
Try to force it, and it'll be used people will either get it, and they'll go, that's a great concept, and that's how we should be doing it. Because at the end of the day, if you put your property on the market, you want to get it sold at the right price in the quickest time as possible. If this was a few weeks ago, where everything's just gone on, you'd probably lost a buyer.
the problem is that people always say they want conveyancing to be faster, but at some level it's not true, because what people also want is conveyancing to be really, really cheap. And and it's not a triviality. People, the general view of the public is that conveyancing is some easy peasy job, and it's like buying a car, and it just ain't, and it never will be. And so the cost of conveyancing has been driven down to very low levels. And I don't.
But why have conveyancers allowed that to happen?
Well, I think the legal industry has cooperated in this, and there's actually been an unholy alliance with the legal industry driving costs down, with consumers wanting costs driven down, with increasingly large chunks of those fees actually being paid as referral fees to various parties along the way.
Yeah, half of their fee sometimes.
And up to half the fee. And the reality is that leaves very little money to pay people to do it. And it's then done by underqualified people with lack of experience. And the reality is, if people want conveyancing to be a lot faster, it will cost you more money. You have to choose.
It's about the weakest link, though, because you could invest and spend on a good solicitor, a good conveyancer, but if
there's a chain, you're stuck.
So if you're a vendor, you have a good. But then the buyer's solicitor is rubbish.
But it's not just a chain. There are several bottlenecks in each transaction times the amount of transactions.
I
So
agree.
what you can do about that is if a buyer is using a crap solicitor and you've invested in a good one, it's still going to fall down at their solicitors.
I agree, but the reality is if you're paying more for your solicitor, what tends to happen is we just get on the phone and call them until they give up.
Because you can justify the resource to do so.
But because we can spend that money because you've paid us more. But if everyone uses a bad solicitor where the fee is very low, they've got no motivation to do that. And I say the biggest problem is not that one part in practice, not one party causes delay. It's an amalgamation of multiple delays.
So you had a question. Are we changing gears to a different subject?
On the same topic, I think one
Yeah.
of the problems why the delays are getting longer is mortgage lenders are asking more and more questions. The underwriters,
Especially this week.
Yes.
they have a long checklist of things that they want to be dealt with prior to exchange of contracts. Whereas we're hearing about the auction process is far quicker, but then of course more often than not there's going to be a cash purchase, so there's no mortgage lending involved.
So you're saying that the mortgage lender's criteria, as it becomes more and more protracted and complex, adds to the problem?
Which is why we're seeing longer delays. In my experience, my personal experience of buying property.
Yeah,
although to an extent, though,
More and more things with every successive transaction, there's more.
I think
detail.
what's incredibly difficult about this problem is actually it's one thing for all of us to complain about it, but actually you guys don't have the problem to the extent that your average first-time buyer who can't afford to pay lots of money to a solicitor, who is really strapped on a very difficult mortgage with very with tough terms that they're having trouble affording, their position is much worse. And the other difficulty here is that not only is it annoying from a business perspective for people who are using this as a business, it's actually incredibly harsh and unfair on some of the most some of the poorest and more vulnerable people who are desperately trying to buy their very first house and to make a home for themselves. So it's actually one of these things that in fact you would have thought a Conservative government would be desperate to do something about.
Well, they've got other things on their plate, I suspect.
Well, yeah, putting up
sir,
interest rates.
You had a question.
To get a charge on someone's property, do you have to go through all that section court or that section 20 whatever process?
Well,
or is it to do with the money order thing? Is it something separate?
Sorry, going back to the question of possession and getting your money back from a tenant that owes you.
You can't have a charge on a
How do you
property
get a
without a
charge?
court order.
And how do you get the court order? Is that section?
Don't have to. It depends. I mean, you can if they owe you money, you can go through Money Claim Online and get a money order.
Right.
You don't have to evict someone to get a money order.
Oh, okay, so it's a completely separate process.
Well, there are multiple different processes depending on what you want to
Well,
achieve.
because the AST acts as the contract, which therefore has been breached, presumably. Yes.
So if you've had someone in your property who owes you money and has left, then you can simply go to use the Money Claim Online service. Primarily is the best option. Get a money judgment against them, and then you can then seek to convert that into what is first called an interim charging order on their property, and then you convert that into a final charging order, and then you may be able to convert that into a power of sale. But I should point out to you, just bear in mind that it is quite difficult to get the court to sell a house if what you are owed is a relatively small percentage of the total owing on the house. Traditionally, what we used to do was get charging orders for like 10 grand, and then you would go off to the mortgage company. And the
it would sit
mortgage
there as a
company,
charge forever.
well, the mortgage company wouldn't want another charge on the property. So what they would do is they would pay you, add it to the mortgage, and add on loads of penalties and laugh.
Which is okay for you, though.
Which was
as
fine for
the
you.
claimant.
But increasingly, mortgage companies don't do that.
Yeah.
What they do is they say, well, we don't care, your charge is behind ours anyway. So we're just going to ignore it, and we'll put on some penalties and charges on the mortgage because they weren't supposed to do that, and we'll still laugh.
You've got to go through the process first. Lady here at the front.
I wanted to ask a question commercial lease.
Commercial lease. Okay. I'm sure between the competence here we can answer the question.
We can try.
What's the question?
With reference to commercial lease, if the landlord has to forfeit the lease due to non-payment of rent, should the landlord be obliged to give 21 days notice on the TOTS law before eviction? And is it lawful to change the laws without giving notice on the TOTS law?
Wow, this sounds like a law school question. So can I read it back? Can I just read it back because there's cameras rolling? So do you mind if I just read that back?
There's another part of it as well.
It's a great question, very technical. Let's hope we can answer it.
I don't know if you can read my handwriting.
It can't be as bad as mine. So, wow. Okay. Are you a doctor? You're in the medical field.
I'll
Seriously.
help you out, Russell,
Well,
because
yes.
I remember the question.
With reference to a commercial lease, if the landlord has to forfeit the lease due to non-payment of rent, should the landlord be obliged to give 21 days notice under tort law before eviction? Who wants it?
I can answer this unless someone else.
Okay.
So, if it's a purely commercial lease with no one residing in the property and you have a forfeiture clause in your lease, then you are entitled to self-help by changing the locks and taking control of the property yourself. You're talking, I presume, when you say the torts law, you mean the Torts Goods Act, or I mean, you don't have to give notice of self-help eviction. There's no law that requires you to give notice. What you have to do is comply with the forfeiture clause in the lease. So basically, if the lease forfeiture clause says they have to pay you the rent within 21 days and they haven't paid it, you're entitled to go in there when no one's there and change the locks and take control of the property. There is then a process in relation to the goods on the property, which is called CRAR, called Commercial Rent Arrears Recovery, which sets out a fairly complex process for distraint of goods. But that's kind of a somewhat specialist topic.
You definitely need a lawyer. Don't do this yourself.
But the starting point is, yes, in principle, you can change the locks.
And if the business is sold to the person who took over the lease, am I obliged to show them Schedule 2?
Well,
Schedule 2 is what is included in the sale. Schedule
well, now you're making it more complicated. So you're saying you had a lease with one company and then the lease was assigned to somebody else?
No, I bought the business and I had the torts law. But the person who took over the business, who bought the business, no, I didn't sell the business to the person.
So are you the tenant or the landlord?
I'm the tenant.
Right.
So the person who took over the business
hasn't paid the rent.
I did not sell all the items, just some of the items which were included. But they want me to show them Schedule 2, and I have refused.
Okay, this is way beyond the scope of something
Yeah.
I can answer in this
to
context.
seriously go and see a lawyer. You need to engage a lawyer, and it sounds like in terms of the investment in doing that, it would be worth your while, I suggest.
Yeah, I mean, the basic rule is if the goods are on the premises and the lease has been forfeit, the landlord can seize those goods subject to various regulations. You may not be the owner of the goods. That's just tough. The landlord's forfeited the lease if it's on the premises. If it's a car parked in a parking bay, which is part of the premises, he might be able to seize those goods.
Yeah, but the goods were removed. But some of the goods were sold. The person
This is very complex.
Yeah, so
this is
the-
too
Yeah.
complex for now.
I think you're right. The Tort of Interference with Goods Act is a specific act that requires you to give the person who's going out, the tenant, the outgoing tenant, a reasonable notice. Sometimes that notice can be 7 days to say collect your goods within 7 days. And if you don't collect the goods within that specified period of time, which can be 7 days, then they're allowed to auction the goods, they're allowed to sell the goods, they're allowed to take the goods and do whatever it is. So I think, as the other people have mentioned, we would need to see the documentation to be able to advise you fully, but we are aware of the statutory instruments that you make reference to.
So, and I hope that's been very, very helpful. Look, ladies and gentlemen, I'm being told incessantly we need to wrap up because we've taken 45 minutes into an hour and 5. Look, thank you to my panel. That's fantastic advice, I think, and free advice. So thank you very much. And audience, thank you very much for coming along and for contributing so fantastically. Thank you very much indeed.